All rise. Veuillez vous lever. Please be seated. Veuillez vous asseoir.
We continue with the closing arguments by the common legal representatives of the victims, and I give Ms. Masida the floor.
Thank you, Mr. President. Your Honors, in light of the already extensive submissions before the Chamber, including in relation to the victimization of our clients, as eloquently transmitted to the Chamber this morning by my colleague, and which I share, my closing remarks today will address the main issues of interest of the victims we represent, who are for the vast majority Acholi. I will first address the LRA policy of attacking the civilian population. I will then turn to the policy of abducting girls and women, as well as children under the age of 15. And I will finally discuss the liability of Mr. Ongwen and conclude with some words about the expectation of victims from this trial. The prosecution has presented evidence which allow concluding that all crimes charged against Mr. Ongwen have been proven beyond reasonable doubt, and that the accused bears criminal responsibility for said crimes. Some elements contained in the description of events by victims corroborate the evidence presented at trial. As reflected by the victims' account of the events, since 1986, there was increased tension and multiple episodes of violence in northern Uganda. The raising of the LRA as insurgency movement aiming at overthrow President Museveni's government spread violence in different areas of the country, including Gulu, Kitum, Pader, Lira, Adjumani, and Soroti, all areas where our clients lived or still live. As a consequence, a conflict of a non-international character started between the government of Uganda and the LRA. The LRA had a clear hierarchy, was well-structured and well-organized, armed, and able to plan and successfully implement hundreds of attacks against the civilian population, in the course of which numerous crimes were committed. The LRA not only had effective tactics in implementing attacks, but had significant military ability. Mr. Ongwen was aware of the existence of the armed conflict and engaged in military operations. The victims' account of events reveals that they were unarmed men, women, and children who suffered from a series of acts of violence, or, put in other words, a campaign or operation carried out against them by the LRA in the localities where they lived. The victims' account of events also reveals that the crimes they suffered from were neither spontaneous nor isolated acts of violence, but rather part of a planned, directed, and organized attack against them, targeted mainly because, as residents of the IDP camps, they were perceived as supporters of the government or as helping the UPDF and not supporting the LRA insurgency against President Museveni. The attack was perpetrated over a long period of time And it was both widespread and systematic. In this regard, the number of victims affected by the events within the charges is one of the most relevant factors to be taken into account for the purpose of determining, under the chapeau of Article 7, Paragraph 1 of the statute, whether the attack launched by the LRA against the civilian population was widespread and/or systematic. The broad geographical spread of the victimizations, as heard by the Chamber this morning, and the large number of victims participating in this case, 4,065 to date, confirm the widespread nature of the attack against the civilian population. In fact, the vast majority of participating victims suffer from the 4 attacks charged against Mr. Ongwen and had to flee their homes, lost at least one or more of their family members, they were injured in the course of the attacks, their properties were pillaged or destroyed, women and girls were either raped or subjected to other gender-based crimes. Some got pregnant and gave birth to children in the bush, who have in turn been victimized and stigmatized ever since. According to the expert on Acholi culture and trauma who testified at trial, Professor Muzizi, quote, "The LRA raided villages, stole the people's food and livestock, plundered villages, and kidnapped children. They burned people's houses as well as the food granaries and left them to the mercy of the elements. They kidnapped the young boys and men and abducted the girls, including schoolgirls. Over 30,000 children were kidnapped or abducted by the LRA between 1986 and 2007, when the LRA was kicked out of Uganda and the insurgency ended. The Acholi village life and self-sustenance traditions were all lost. Farming traditions, family cohesion, culturalization, schooling, and food security were all lost." End of quote. There is ample evidence in the case record before this chamber supporting such a modus operandi of the LRA in its operations. Victims of the 4 charged attacks recall a particular pattern of the LRA in attacking IDP camps. The attack was well planned and well executed, following a standard modus operandi which aimed at targeting the UPDF on one side and the civilians on the other side. Victims also put emphasis on the brutality with which the attacks were conducted, indicating that the LRA rebels put houses on fire, often leaving or throwing people inside, including babies, obliged residents of the camps to lie down on the ground, and brutally mistreated, beaten, and killed them, with no pity for children, elderly, and women, who often were also raped before being killed. Victims recall the abductions of adults and children as young as 7 years old, to use them as soldiers. The pillages and the destruction of private and commercial properties, explaining that the LRA took everything they owned, including all goods necessary to sustain life in the difficult conditions in northern Uganda. Pants, caps, clothes, as well as livestock, constituting the key source of income of families, and other properties carrying a specific meaning for the affected communities, notably, as also recalled this morning by my colleague, for the accomplishment of traditional rituals. The ones who survived the attack had to leave their homes, to flee, and take refuge far away from their places of residence, often leaving back members of their families. The severity of attacks appeared to come in waves, with major massacres interspersed across an ongoing campaign of low intensity with small-scale assaults. The LRA rebels routinely cut off lips, ears, and breasts, gouged eyes, and amputated limbs. Many of these mutilations were carried out to prevent betrayers. Victims were abducted to help carry looted goods, causing them psychological and physical harm, such as feet, chest, and back pain. When too old to stay as an abductee, they were either released after a short period of time or more often killed. According to the victims, the recognition of a crime of persecution in connection with the attacks is therefore an important element shown by the evidence presented at trial. The LRA rebels severely deprived, contrary to international law, the civilian resident in Pajule, Lukodi, Odek, and Dabok of their fundamental rights to life, liberty and security, freedom of movement, private property, not to be subjected to torture or to cruel and inhuman or degrading treatment, and not to be held in slavery or servitude. The evidence at a trial allows concluding, as shown by the prosecution, that 1. The LRA had the capacity to commit a widespread or systematic attack against the civilian population. 2. The LRA was a group in an established hierarchical way with the capacity to impose a policy on its members and to sanction them. 3. The LRA had communication ability, weapons, and ammunition in order to carry out the attack against the civilian population. 4. The LRA acted for a long period of time for a common purpose of overthrowing the Uganda government. 5. The LRA followed a regular pattern in implementing its policy of persecuting, murdering, pillaging, torturing, enslaving, raping, or otherwise committing gender-based crimes, inflicting cruel or inhuman treatments, and abducting adults and children. Mr. Ongwen had knowledge of the attack and contributed substantially to the common plan. I will now turn to the LRA policy and practice of abducting women and girls. Victims indicate that rape, sexual violence, sexual slavery, forced marriage, and forced pregnancy were crimes systematically committed by the LRA rebels, including by senior commanders and notably by Mr. Ongwen, on the one hand, to recreate a new generation of Acholi people nested in the LRA beliefs, and on the other hand, as rewards and slaves for soldiers. Abductions were normally perpetrated during the attacks. Top commanders would describe the type of girls they wanted, including age, physical appearance, and intelligence. If recent abductees matched these desired characteristics, then they were collected and distributed to the commanders. It was an order to go to those men and become their wives. Resistance was punishable by rape, severe beating, torture, or even death. Once the senior commanders selected the girls they wanted, the lower-ranking fighters would do the same, or were distributed with one left. Several witnesses testified about the phenomenon. P0099 explained, and I quote, "The leader con calls for an assembly. Sometimes he calls this assembly on Sundays. Then these girls are paraded. Then, if he decides to give an order that the girls be distributed, then that will be done so. But if he decides that the girls be sent to someone's home, then they can do that." End of quote. P0214 recall that each commander would come and point to the girl that they wanted. As explained by P0226, and I quote again, "The girls who were selected do not have a voice. If you are told to go there, then you must go. If you refuse, you were either beaten or killed. Some of them were used as babysitters, others as wives." End of quote. P0235 directly saw Mr. Ongwen distributing girls in Uganda and in Congo. During her testimony, she said, "The girls would not be able to choose because when you are abducted, you don't even have the feeling of staying with a man. You only keep on thinking about your home. So we will not choose the man." End of quote. Mr. Ongwen was implementing the policy of abduction of the LRA, even at times when Con himself has suspended the practice. In this regard, P0245 remembered one occasion when the accused came across to two young girls and commented, "They are too beautiful to be left behind." As a result, the girls were abducted. The chamber also heard several accounts of what the life looked like for a forced wife. Performing different domestic duties, such as cooking, fetching water, washing, doing laundry, collecting vegetables, cutting grass, carrying utensils, gardening, under constant fear of being beaten or killed. In the words of P0236, quote, "If you do anything wrong, you are beaten. If your things are dirty, you would be beaten. If you are not listening, you would be beaten. If you listen, you are not beaten. If you listen to what they are telling you, you are not beaten. But if you forgot, then you are beaten." End of quote. Forced marriage is prohibited by many human rights instruments, providing that no marriage shall be entered into without the free and full consent of intending spouses. While forced marriage does involve rape, sexual violence, and enslavement, the crucial element of a crime is the mental and moral trauma resulting from the imposition by force arising from the perpetrator's words or conduct of a forced conjugal association and the relationship of exclusivity between the so-called couple. Forced marriages are coercive relationships without valid consent of the women. They have the characteristic of shared domicile, bearing of children, domestic responsibilities, exclusivity, and sex. The nature of these relationships force girls to take on roles as sexual partners, mothers to the children born from these relationships, cooks, domestic workers, water collectors, porters. The relationship consists of a familial aspect where children are born and raised by abducted mothers and their captor husbands. The use of the label wife causes a unique psychological suffering, which often leads to stigmatization and rejection of the victims by their families and communities. Forced marriage also inflicts grave physical injury and results in long-term moral and psychological suffering of the victims. All affected victims we represent indicate that their condition of wife had and still continue to have serious repercussions on their possibility of restoring what they call a normal relationship with men. And that even if they are reintegrated in the community, they feel that self-reintegration is not, to use again their word, full, and sometimes only dictated by social conventions more than by a genuine will to help them in rebuilding their lives. As explained by Professor Musisi in this curtain, what happened to the abducted girls in the LRA is not only criminal, but runs astray of their cultural landmarks. What these girls went through while in captivity remains a taboo in their families and communities. Once back, they carry the stamp of having been forcibly married in the bush, while no official marriage had in fact occurred in accordance with Acholi traditions. This creates, another point also made by my colleagues this morning, identity problems, difficulties for daily subsistence, and land issues. The evidence demonstrates, beyond reasonable doubt, that soldiers under Mr. Ongwen's command committed gender-based crimes against many girls and women, and that the accused gave orders and instructions for the commission of said crimes. This is proven, Your Honor, rendering meritless the defense arguments addressed in the closing brief at paragraph 475, according to which, and I quote, Con created a coercive environment in which survival depended on following the rules, including regarding relationship between men and women within the LRA. In the specific case of Mr. Ongwen, a distinction must be carefully drawn between following the rules, which in itself is not exculpatory for the modes of liability alleged in any case, and exceeding the rules. The fact that trauma triggers survival skills in children and adults alike, as recalled by the defense at paragraph 588 of its closing brief, is undisputed. Whether exceeding the rules and unleashing total brutality can be qualified as survival skills is hardly doubtful. In this regard, the testimony of Professor Vessels offers some contrasting information about the possibility to react to coercive environment. Quote, well, some people have said that when they were given the orders to fire, they fired in ways that were ineffective. Sometimes they moved slower on a march. Sometimes they tried to leave clues that they were around. So it really depended on the individual. And sometimes even children who had become low-level commanders, but who had some status within the LRA, reporting doing such things. These two, I think, indicate that despite following the orders, and even to some extent getting catch up in the propaganda of the LRA, quite a number of people still knew right and wrong and wanted to protect members of their own family. End of quote. Mr. Ongwen is also charged with the direct commission of a number of gender-based crimes against at least 7 women. The testimonies of Mr. Ongwen's forced wives shed light on common elements of their stories. They were fairly young when they were abducted and chosen to become his wives, which invariably happened by a first act of rape committed by the accused, followed by repeated forced sexual intercourses with their rotation amongst the wives, depending on whom the accused was calling at night. They did not have a choice. They started by doing some tasks in the household as teen things, tasks they continued doing once they became wives. They were under constant guard from the accused and or his armed soldiers, subjected to beatings and cruel and violent acts, either directly perpetrated by Mr. Ongwen or ordered by him. Daily forced to do things they did not want, living in constant fear, thinking of home, missing their loved ones, worrying about their fate, exposed to dangers of attacks and combats in which the LRA engaged, and some of them sustained injuries. The traumatic experiences they suffered from and the physical harms inflicted on them by cruel and inhuman treatments and torture have affected them permanently, as they suffer from different types of trauma. They gave birth to children born in the bush and fathered by the accused. Children who in turn were seriously affected by the difficult conditions in which they lived during the very first essential years of their life. As a consequence, both children and mothers have been facing enormous difficulties in reintegrating in their families and communities, in making a living to support their children and their own daily subsistence, in going back to their lives, let alone to continue their education and start rebuilding a new life for themselves and their children. The prosecution has quoted yesterday the account of P0227 describing how she became a wife to the accused. That account is not unique. A similar account was provided by the other forced wives who testified. P0214 recalled, quote, "The security guards scared me with the sticks, so I went to Ongwen Place. He told me that I had already been smeared and I was therefore ready to be his wife. He told me he will teach me how we were supposed to stay with him. He said, when a man, your husband, calls you, you should not refuse. Ongwen told me to lie down, and I did, as I was scared of the security guards with their sticks. He pulled his shorts down, but he did not remove them completely. I looked at him and saw his penis, which was uncircumcised. I did not see anything else. Ongwen took his penis and put it inside of my vagina. I was scared, as he wanted to sleep with me, and I have never slept with a man before. I was crying, as I was told at home that I should not sleep with a man in the bush. I was told that if I slept with a man in the bush, I would not have children, or the children would die. Having sex with him wasn't my choice. The account is even more shocking, Your Honor, when heard by P0226, a 10-year girl at the time she was first raped by the accused. Quote, I was not sexually mature. He asked me to bring him water. When I took the water, he held on my arm. He refused to take the water from me. He told me that he wanted to have sex with me. I dropped the water. It fell on the bed, and I ran out. He called his escorts to beat me. He instructed his escorts to get stick and start beating me. They used bamboo sticks. I was on the ground. I was being beaten. He, meaning Dominic Ongwen, was sitting there, watching. I was beaten for about a week because every time he asked me to have sex with him as his wife, I refused, and I was beaten. My hands and my buttocks were all swollen, and I could not sit properly. I could not take the beatings anymore. So I let him have sex with me. It was very painful. End of quote. The evidence demonstrates, beyond reasonable doubt, that Mr. Ongwen directly committed the crime of rape towards at least 7 women during the period covered by the charges, by inflicting them with multiple, repeated, and regular acts of penetration under coercive circumstances and conditions of which the accused was undoubtedly aware and conscious based on the victim's reactions. There is equally substantial evidence demonstrating that the victims were abducted and kept against their will in the LRA in the midst of an armed conflict. The evidence also demonstrates, beyond reasonable doubt, that Mr. Ongwen committed the crime of sexual slavery by engaging in one or more acts of sexual nature while exerting a power of ownership on his victims who were placed in situation of enforced deprivation of liberty.
Ms. Masida, it's the first time today that I have to say that, so we improved in comparison with yesterday, but please slow down a little bit.
Thank you. I was also alerted by my team. Thank you, Your Honor. The evidence further demonstrates, beyond reasonable doubt, that Mr. Ongwen committed the crime of forced marriage by imposing a so-called marriage on girls and women in his household, perfectly aware of the coercive environment and action he was imposing upon the victims. The pre-trial chamber in confirming the charges against the accused, held for the first time before this court that forcing another person to serve as a conjugal partner may per se amount to an act of a similar character to the ones explicitly enumerated by Article 7, Paragraph 1 of the statute, intentionally causing great suffering or serious injury to body or to mental or physical health, and that the crime of forced marriage is not subsumed by the crime of sexual slavery. A finding further confirmed more recently in the Al-Hassan case by both the pre-trial and the appeals chamber. Victims asked the trial chamber to confirm this interpretation of the law, recognizing that restrictions on the freedom of movement, repeated sexual abuses, forced pregnancies, or forced labor, in particular, forced performance of domestic duties, are all factors which indicate a situation of forced marriage. Victims also asked to recognize that the central element of a crime is the imposition of marriage on the victim against her will, with the consequent social stigma deriving from it. Victims finally ask that the separate and additional harm caused by this crime, as opposed to the crime of sexual slavery or other gender crimes, is recognized, since this offense violates the independently recognized basic right to consensually marry and establish a family. The evidence also demonstrates that Mr. Ongwen committed the crime of forced pregnancy by confining girls and women he forcibly made pregnant with the intent to carry out grave violations of international law, including using them as wives and mothers, and to rape, sexually enslave, and torture them. As recalled by P0235, becoming pregnant in the bush wasn't my choice. In her victim's application form, she specified the difficult conditions of pregnancies in the LRA captivity, and I quote, "It was a very terrible time for me, as I gave birth in the bush. It was a very hard time for me, as I was helped by my co-wife, who was not even an expert in the field of giving birth." P0236 similarly stated, "I gave birth to 2 sons with Dominic Ongwen, and I am taking care of them without anyone to help me, since I have no source of income because I'm jobless. I feel I have lost my dignity as a woman. Because I was forced into sexual intercourse by a rebel, and I could not do anything to defend myself, that I have even gave birth to 2 sons." End of quote. The words of the forced wives explain in plain words what Professor Ray Schroeder described as consequences of forced pregnancy in the following terms. Quote, "Women who become pregnant following incidents of rape face the scorn of their community. In Uganda, forced pregnancy causes the mother and child stigma in their communities. Children of forced pregnancies serve as a symbol and reminder of the history of atrocities committed by the LRA and are therefore subjects of blame, scorn, rejection in their communities, often being automatically labeled as criminal, rebel, or murderer. Children born of LRA forced pregnancies are deeply affected by their biological origins and subsequent treatment by society. Inequities are noted in relation to children's access to health, education, and employment. An additional form of stigmatization is the naming of the children. A study conducted in a reception center in Ngulu showed that 71% of their sample had names that have negative connotations. These children receive names with negative connotation because their names were a reminder of the suffering and of the captivity. I thought many reception centers changed these children's name. They carry the stigma of their name into their reintegration. The children end up isolated from other children because of their upbringing. End of quote. Your Honors, the LRA has also been notorious for its policy and practice of abducting children to serve as soldiers. I first address one of the most significant evidentiary issues that affect the interests of the victims we represent, which is the determination that children were under the age of 15 during the time frame of the charges. The defense, indeed, in its closing brief, alleges that the age requirement, I quote, has not been established beyond reasonable doubt by the prosecution. The issue of age determination is not new to the jurisprudence of the court and other international tribunals. The practice of the court has accepted the evidence of witnesses who, assessing the physical appearance, the behavior, and or the development of children, concluded that they were under the age of 15. The appeal chamber in the Lubanga case, in its judgment of 1st December 2014, accepted visual assessments of age even when witnesses provided said evidence several years after the events. In paragraph 233 to 235 of the judgment, the appeal chamber clarified that such evidence does not need corroboration and can be relied upon under the only condition that chambers apply a sufficient margin of error. More recently, Trial Chamber 6, in its judgment in the Bosco Ntaganda case, judgment of 8 July 2019, consider that witnesses' age assessment is reliable in light of factors like information provided by members of the family or observed behavior by witnesses. The reference, Your Honor, are contained in footnote 999 of the Ntaganda judgment. Child soldiers. Two simple words. But they describe a world of atrocities committed against children and sometimes by children. Children were used as disposable porters by the LRA, worked quickly. This both increased the LRA mobility and enhanced its capacity to carry loads of looted goods over long distances. forcing children to kill their friends or family members in front of other abductees instill fear and discourage them from escaping. In the words of one of our clients, former child soldier, sometimes they get the new people to kill. You never refuse to kill, otherwise they will kill you. It also forced a clean break with the past, as they were less likely to return to a community where they murdered or looted. The evidence demonstrates beyond reasonable doubt that during the period of the charges, Con and other serious leader LRA commanders, including Mr. Ongwen, pursued a common plan to abduct children in the territory of northern Uganda and conscript them into the LRA, including Insignia Brigade, in order to ensure a constant supply of fighters. Abduction of children was a widespread and established practice in the LRA. Therefore, Mr. Ongwen was aware of the fundamental features of the LRA and the factual circumstances that enabled him, together with the co-perpetrators, to jointly exercise control over the crime. As a result of the common plan, children under the age of 15 were abducted at various locations in northern Uganda and forcibly integrated into the Oka Battalion and the Signia Brigade. Following their recruitment, they were trained for active participation in hostilities and participated actively in combats and activities linked to combat in the 4 charge locations as well as in other places. Abducted children, Your Honors, boys and girls, served as fighters, lookouts, porters, escorts, and bodyguards to LRA commanders, including Mr. Ongwen, and were forced into sexual intercourses. Mr. Ongwen contributed to the realization of a common plan by personally using children under the age of 15 as escort, ordering his subordinate to abduct children under the age of 15, supervising and monitoring military training of children under the age of 15. And he knew that children conscripted into the LRA and used to actively participate in hostilities were younger than 15 years old. The abduction of children was a deliberate strategy aiming at indoctrinating them into a way of acting and thinking. Witnesses at trial recounted how LRA commanders adopted different strategies to indoctrinate abductees. Professor Allen affirmed that accounts about the initiation processes of new recruits vary substantially from one person to another. Some recounting being required to participate in numerous prayer meetings. Others forced to perform violent acts. Others forced to kill friends and relatives. Witnesses also testified about abductees who didn't walk fast enough or refused to obey orders, being severely beaten or killed for refusing to do so. The prolonged stay in the bush had a profound impact on the ability of children to reintegrate in their families and in their community. Victims participating in this case are former child soldiers who either managed to escape or were captured by the UPDF and later set free. Parents of former child soldiers also participate in these proceedings. Some of them have never seen their children again since their abduction and have lost any hope to embrace them again. Others still keep hope of seeing their children coming back one of these days. But ones who had the chance, if we can call it that way, of returning to their families and communities face enormous challenges in trying to return to normal life. They have difficulty processing their experiences and reintegrating in the society. They need healing from traumatic experiences, help with physical and emotional difficulties, education, vocational training, and to establish the link with their community. The way from child soldier to firmly abducted child to finally just a child or a young adult is a long mile to walk, particularly because of a persistent mixed perception of former child soldiers as victims on the one hand and perpetrators on the other. And this leads me, Your Honor, to the part of his presentation which relates to the criminal liability of Mr. Ongwen. The defense challenges the criminal liability of Mr. Ongwen on several bases. First, the defense alleges that Mr. Ongwen is only a victim, abducted at a young age, psychologically manipulated, subjected while in the LRA to injuries, constant fear of death or serious bodily harm, and long-term mental impairment. Consequently, in the view of the defense, Mr. Ongwen cannot be held responsible. This is an argument, Your Honor, which victims consider totally unfounded in fact and in law, and worst, disrespectful of their sufferings. It is not disputed that Mr. Ongwen might have been a victim of one of several crimes when he was a minor. However, this fact alone does not constitute a legal basis for excluding criminal liability under the Rome Statute. The fact that Mr. Ongwen has been abducted at a young age does not absolve him from criminal liability for his acts and conduct as an adult. By arguing once a victim, always a victim, the defense not only negates the paramount principles of human resilience and agency, but it also fails to acknowledge blatant facts, such as that not all victims become perpetrators and criminals, let alone powerful and cruel ones. The event Mr. Ongwen might have been a victim as a child when abducted are extraneous to this trial. What this trial is about is the conduct of Mr. Ongwen as an adult and the actions he chose to take or not to take at the time of the charged crimes. Even if one accepts at face value the defense allegation with regards to Mr. Ongwen's lack of maturity due to his captivity and isolation from the society, the childlike conduct of the accused that has been referred to bountifully in these proceedings has not been established by real and uncontested evidence. The charges that the accused is facing constitute, to use the words of a preamble of the Rome Statute, some of the most serious crimes of concern to the international community as a whole. Victims are of a view that it is impossible to seriously envisage that Mr. Ongwen did not understand at all the extremely grave nature of the criminal acts in which he engaged, as demonstrated by ample evidence in this case. Contrary to what the defense is suggesting, the evidence demonstrates beyond reasonable doubt that during the period covered by the charges, Mr. Ongwen was a military commander in the LRA. He commanded a battalion in the Senior Brigade for much of mid-2002 to March 2004. And then, on or about 5 March 2004, he became the commander of the Senior Brigade. In that capacity, he had effective command and control, or authority and control, over his subordinates during the entire period covered by the charges. Mr. Ongwen knew about the common plan to attack the civilian population, in particular the Acholis, and anyone perceived as government supporters. He participated in meetings to plan the attack charge, gave orders to his subordinates, explicit orders to loot, murder, abduct. More importantly, throughout the period covered by the charges, Mr. Ongwen had the necessary mens rea in accordance with Article 30 of the statute. Indeed, the evidence demonstrates that within the meaning of each of the alternative forms of liability pleaded by the prosecution, and in relation to each crime charged, Mr. Ongwen meant to engage in the conduct and cause ensuing consequences, or was aware that they will occur in the ordinary course of events. None of the grounds for excluding criminal liability have been proven by the defense. As far as mental illness is concerned, in accordance with Article 31(1)(a) of the statute, in order for an insanity defense to succeed, an accused should be diagnosed with a pathology which qualifies either as mental disease, disorder, illness, or defect, in accordance with the symptoms enumerated in one of the instruments used in the medical profession for that specific purpose, and notably the DSM-5, which was extensively used by the expert and referred to by all the experts heard by the chamber. Not only the existence of a specific condition, but importantly, its severity must be observed and confirmed, in other words, proven at the time of the events. This means that the fact that the accused is allegedly suffering from any specific condition now, or at any time since he has been in the custody of the court, is neither conclusive nor sufficient evidence that said condition was indeed present during the charge period. The evidence at the trial point at the opposite direction, as also argued yesterday by the prosecution, because there is evidence that Mr. Ongwen took active part in maintaining and enforcing the system of terror that the LRA operated. He took initiatives, decisions, and actions that fostered the crimes ordered by Joseph Cohen. Mr. Ongwen is known amongst the victims as the most brutal of the men who served Joseph Kern. He has a record of protracted atrocities against his own people and brutality against his forced, very young wives. He was proud of his achievements in the battlefield. He showed no remorse. From the totality of information presented in this case, the victims are of the view that Mr. Ongwen cannot be considered as someone who had been suffering from a mental disease or defect that completely destroyed his capacity to appreciate the unlawfulness of his conduct, or his capacity to control his conduct, to conform to the requirements of law within the meaning of Article 31(1)(a) of the statute. The fact that the accused may have faced, during the period of the charges, extremely difficult personal or emotional situations does not remove legal responsibility off his shoulder, because it's not demonstrated that his volitional and cognitive capabilities were destroyed at the time of the commission of a crime. In particular, the general statement by the defense, according to which expert, I quote, unequivocally placed the mental illness of Mr. Ongwen suffers in the context of a mass trauma experienced in Acholi land in the period 2002-2005 is inapposite because unspecific to the situation of the accused. In this regard, Professor Wessels pointed out, quote, over 25% of children who experience extensive traumatic exposure exhibited post-traumatic resilience in that they did not develop post-traumatic stress disorder, depression, or any behavioral or emotional problems of clinical concern. Consistent with a trend seen worldwide, formerly abducted children in northern Uganda have shown greater resilience than many had expected based on the children's massive exposure to traumatic events. 2/3 of former abducted children reported low to medium levels of emotional distress, and over 90% showed fairly high levels of functioning, end of quote. As explained by Professor Muzizi, based on his experience as psychiatrist who treated many LRA victims, young abducted children can be very suggestible and can be convinced easily. Children exposed to severe stress in childhood get distorted in their ways sometimes, but they don't lose judgment of the right and wrong. The three experts called by the prosecution concurred that being exposed to trauma is not sufficient for a diagnosis of trauma-related disorder. Dr. Abbo clearly stated that she did not find any evidence or evidence sufficient to establish that a mental disease or defect destroyed Mr. Ongwen's capacity to appreciate the nature of his conduct. Professor Mezei echoed this conclusion and interestingly indicated that it would be highly improbable and psychologically incoherent to suggest that there was a continuous as ongoing mental abnormality during the time period of the 4 charged attacks, spanning over a period of months, or that a mental abnormality occurred coincidentally with each of the 4 attacks. This because the attacks appear to have been planned and premeditated rather than impulsive, which would not be compatible with a person dissociating every day through months or years, as alleged by the defense. In her opinion, the likelihood of the accused suffering from mental illness every day throughout the period of the charges, almost 3 years, while committing planned and premeditated conducts that continued over time, such as forced marriage, slavery, or conscription of soldiers, would be entirely implausible from a medical standpoint. Your Honor, even assuming that the accused was allegedly suffering from an illness at the time of the crimes, a conclusion that we challenge, having been made by the defense expert years after the events, the only reasonable inference from the expert testimonies and the evidence taken as a whole is that certainly said illness did not reach the degree of severity required to destroy Mr. Ongwen's cognitive or volitional capacity. Nor the argument of the defense in its closing brief that Mr. Ongwen was, and I quote, having dissociative amnesia in battle, making impossible for him to control his conduct, end of quote, can be seriously upheld. If this was true, the fact that the accused survived all attacks and ambushes while in the bush is quite miraculous. The defense also alleges that any acts during the charge period would have been committed under duress caused by Joseph Kony and his close advisors. However, as also pointed out yesterday by the prosecution, there is no indication in the record of the case that Mr. Ongwen, during the period covered by the charges, was actually under duress. Several witnesses testified that the accused was not afraid at all of Kony, arriving at questioning his orders openly on several occasions and disagreeing with him. Several witnesses also testified about the initiatives taken by the accused when deciding to attack location, showing that Mr. Ongwen was quite proactive and ingenious in implementing the LRA policy of brutality, negating duress. Duress is an excuse which is premised on the idea that the actor is incapable of making a moral choice due to the overwhelming force of a threat. While it could be argued that children under the age of 15 may not be always able to distinguish what is wrong and what is right, and that the conditions of a forced recruitment imply threat, this assumption cannot be valid for someone who reached the age of reason, who was in position of power in the LRA, and who was able to make a distinction and subsequently choose between what was wrong and what was right. The defense also appears to argue that the spirituality within the LRA, namely the spiritual power supposedly exercised by Kony, posed a threat of imminent death or of continuing or imminent seriously bodily harm against Mr. Ongwen. In its closing brief, the defense asserts that what makes this case peculiar is its specific factual situation, and I quote, "Schroeder in spiritualism and mystical." Self-evidently, in a procedure in which the majority of the participating victims are Acholi, and in which a considerable number of witnesses were heard on cultural aspects of importance for people living in northern Uganda, the cultural issue is an important one. Understanding the cultural context is certainly of paramount importance out of respect of all participants in this proceeding. But it is also central to appreciate the impacts of the crimes committed. This being said, specific cultural features cannot be used to imply lack or to diminish liability. While many witnesses testified about the religious and spiritual beliefs within the LRA, the evidence shows that not everybody in the LRA believed the so-called spiritual powers of Joseph Kony. In any case, there are evidence showing that Mr. Ongwen willing remain in the LRA, sharing the objectives and purpose of the organization. And in fact, the absence of any meaningful sign that the accused wanted to dissociate himself from the LRA and from the criminal acts that he committed negates duress. Therefore, Your Honors, the victims consider that the evidence heard at trial militates for concluding that Mr. Ongwen had, at the time of the charged crime, the knowledge and intent to commit all the charged crimes.
Oh, she's still there.
Mr. President, Your Honors, at the beginning of this trial, the Chamber was presented with a short video in which victims expressed their expectations from these proceedings. I will recall briefly two quotes from that video which summarize the hopes of victims. Victims 0605115 indicated, and I quote, "The suffering I went through were enormous. Life is hard now. I was abducted as a young girl and forced to become a rebel's wife. Every time I mention what happened to me, I feel the trauma and the bad images come back. I wish I could live for another place so that I can live in peace with my children. Here, I'm stigmatized because people do not completely forgive us and keep pointing out at us as the ones who were in the LRA. The sufferings I went for can never be compensated, but the court should make us feel that justice is done so that we can live knowing that justice exists." End of quote. Another victim, 807041/15 stated, and I quote again, "When I think about justice, I mean that I want the truth about the events I suffer from. And like me, many others in Uganda, we want the truth to be established so that we may be satisfied. I want the court to work well and this case to end in a just manner. I trust the court to dispense justice for us, survivors. The duty to establish the truth is not limited to establish the guilt or innocence of the accused. Part of the truth to be determined by this chamber is the victimization, the suffering and harm caused to the ones who were directly affected by the crimes committed. During the course of the trial, the Chamber heard evidence about the crimes committed, as well as factual and emotional accounts of the agony suffered by victims, their families, relatives, and communities. Victims expect that in its evaluation of the evidence, the Chamber gives also due consideration to their accounts and to the harms they suffer from. The extent of the prejudice suffered by civilians in northern Uganda, and in particular the Acholis, is tremendous, as also recalled this morning. The horrific and prolonged consequences of the war had an impact not only on the individuals, but devastated the society, and particularly eroded the solid and rich culture of the Acholi social structure. One final word, Your Honor, on the issue of accountability of Mr. Ongwen, in light of the defense request that the accused be placed under the authority of the Acholi justice system to undergo the mato put ritual if declared guilty. It's evident, Your Honor, that the request cannot be entertained by this chamber because such a remedy is certainly not enshrined in the legal text of the court. But my point, and more importantly, said request is contrary to the interest of the victims participating in this trial. Mato or put, literally drinking the bitter herb, is a traditional practice of Acholis only, to resolve inter-clan disputes, such as the killing of one clan member by a person of another clan. It's a long process, very elaborated ritual, which was never intended to deal with mass atrocities, nor with killings during times of war. It's a specific tradition to Acholi. Not all victims participating in this proceeding are Acholi, and for them, said ritual may not be meaningful. In any case, victims have throughout the entire proceeding expressed their expectation for justice. They want a court of law to establish that Mr. Ongwen is guilty of the crimes they have suffered from and the acknowledgement by the accused of his wrongdoings. Victims expressed the view that the request that Mr. Ongwen simply undertake a mato or put ceremony equals to a request of impunity. Impunity, the only word they hope to never hear again after the surrender of Mr. Ongwen, certainly not in this court of law. In conclusion, Your Honor, victims consider that the liability of Mr. Ongwen has been established beyond reasonable doubt for all charges brought against him, and ask the Chamber to declare the accused guilty of all crimes. Before I sit, Your Honor, allow me to remember my sister Jane Adong, who the circumstances of life will not be able to see the end of this trial. Without her invaluable contribution and advice, I would never have been able to represent before this chamber the interest of our clients. And I will thank you, Your Honors, and our clients will thank you. Afoyo Matek.
Yeah, please, Mr. Ayena, what's...
Mr. President and Your Honors, we have some very serious objections to raise about the manner in which the submissions of Mrs. Maseda Your Honors, she has gone far beyond her mandate as counsel for the victims. Your Honors should be reminded that it is the duty of the prosecution to challenge, or rather to prove, the guilt of the accused. And it is not the role of counsel for victims. What does what her submission amount to? Your Honors will appreciate that there is this principle of equality of arms in this court. Look at the array of land people on that side. If they were to be merged together, as Mrs. Masida has now done, then the concept of equality of arms in this court will diminish. Actually, I think we shall propose, and I think conveniently, that all counsel of defense teams should approach the CSS to remove the office of the PC, of the counsel for victims from the other corner and bring them to this corner of the building, because in effect, they are one and the same with the prosecution. And what does this lead me to? Mr. President and Your Honors, it is our strong view that the submissions of Ms. Maseda should be expunged from the court record because they were overboard. Thank you very much.
Your Honors, just one thing.
No,
There's a
I
discrete,
think this is
issue.
no, we have now. No, we don't start now a
Yeah.
prolonged litigation about past presentations.
Just one point, Your Honors.
Yeah.
You
Keep it very shortly, please.
You reserve a discrete issue for further submissions and establish a timeline. She's got up now. Instead of respecting the court order, she tries to address that issue here within submissions. And furthermore, you define the role in the decision of victim representation before this court several times. She has clearly abused that mandate, Your Honor.
Of course, I have to give you, Ms. Masida, shortly the floor also for response.
Thank you, Mr. President. I made clear when I started my presentation that my presentation was based on the concerns and interests of my clients. All the points that I have raised related to their interest, including, and of course, Mr. President, the issue of liability of Mr. Ongwen. This is a core interest for our clients. We have been intervening on this point throughout the entire trial. Thank you very much, Your Honor.
I think the Chamber has already conferred. The objection is overruled, and especially there will be no expurging of any presentation by the common legal representative of victims. It has to be reminded that the purpose of closing statements is for the parties and participants to state their final position on the case to the Chamber. They are not, and this has to be underlined, and there is a difference to what we have done before. They are not evidence. The presentation of evidence has long been closed. In fact, closing statements are arguments, and counsel are to be given considerable latitude in making them. This coincides with the practice of national jurisdictions and international tribunals. So the important point is we are hearing here legal, factual arguments, and not evidence is put to the Chamber. And you know that you have this different approach to evidence put by representatives of victims. And you, especially defense, can be sure that the Chamber understands this distinction and is able to properly put into perspective everything what has been said in this courtroom during the past days and will be said tomorrow during the closing statements. This concludes this short ruling. We conclude the hearing for today, reconvene tomorrow 9:30 with a presentation by the defense.
All rise.